So this scenario is going to take us through the defense of mistake. Obviously, you would establish your offense before your defense, but let's have a look at how the defense might work. So starting with the question, first of all, we're advising Abdi of his criminal liability towards the waiter and towards Mari. And the scenario is Abdi sees Mari being hit by a waiter at a restaurant. Abdi throws the waiter off, causing the waiter to break his wrist, and Mari was actually choking and dies from asphyxiation. So first of all, we've got to introduce the defence of mistake by using the case of Arm Reed. The defendant must have to make a mistake in the facts, not a mistake in the law, and ignorance of the law is no excuse. So we need to explain what that mistake of facts means. Well, it means that the mens rea of the offence must be made negative by the mistake. The defence can be used when the defence actions can be justified or excused in some way. And a statute may also provide specific instances where the defendant has a lawful excuse. So, for example, the coronavirus restrictions that have been in place, you initially were not allowed outside for very many reasons unless you had a lawful excuse. But in this case, the mistake that Abdi made, he was mistaken in believing that the waiter was hitting Mari, and when the waiter was actually delivering the Heimlich manoeuvre. So there is a mistake, and it does negate the mens rea. Abdi in no way meant to commit an offence here. The mistake must be reasonable. Now, this has developed over the years. So initially, Tolson from 1889, our defendant remarried thinking her first husband was lost at sea and dead, and then the husband turns back up again, and the court held that this was both a reasonable and honest mistake. But the question developed around did your mistake have to be a reasonable one? The case of DPP and Morgan said that the belief only had to be genuine and not necessarily reasonable, and this is confirmed in Williams Gladstone from 1987. It removed the reasonable belief that was initially removed in Morgan, and the defendant has only have to have a genuine mistaken belief. It doesn't have to be reasonable. So in our scenario with Abdi, it appears that he honestly believes that the waiter is hitting Mari, and actually the mistake is genuine even if it's not reasonable. And finally, the mistake cannot be used as a defence where the defendant is voluntarily intoxicated. This is where your intoxication and mistake overlaps. So from the case of O'Grady, the court held that an intoxicated mistake as to how much force was needed, or even the use of force itself, did not provide a defence. And this is confirmed later on in Fotheringham, which says an intoxicated mistake cannot be used. In this case, evidence would be required to prove this, but there's no suggestion actually that Abdi is intoxicated. If in a scenario question like this, if your defendant is intoxicated, you would be told very specifically. And therefore, we can conclude Abdi is likely to be able to use the defence.